Imagine waking up one morning in Richmond, British Columbia, to discover that a court has recognized an Indigenous nation's title over the very land beneath your neighborhood. The roads you drive on, the dikes that protect your home, maybe even the golf course down the street. You still hold a property title. Your house hasn't been seized. But suddenly, lawyers, politicians, and judges are arguing about whether your indefeasible title is actually defeasible, whether someone else's legal right to that land might sit above yours. That's exactly the fear spreading through parts of BC right now after a landmark court ruling recognized Aboriginal title for the Cowichan Nation over a large area in southeast Richmond. An area that includes public lands, federal lands, and is surrounded by private homes and businesses. The provincial government says, your private property is safe. The Cowichan Nation says it's not trying to take anyone's home. But one of Canada's leading Aboriginal law experts says this ruling puts private land ownership in jeopardy, and that BC may now be the only Western economy on the planet where you can no longer confidently take your land title to the bank. In this video, we're going to unpack what's really going on. What is Aboriginal title? How does it interact or collide with private property? Why are politicians warning about secret land claims and land back deals? And what does this all mean for reconciliation, investors, and ordinary homeowners? Stay with me to the end, because by the time we're done, you'll understand why this isn't just about one case in Richmond. It's about how ownership, history, and justice collide across huge parts of British Columbia. Let's start with the case that triggered the current storm. Cowichan Nation versus the Crown in southeast Richmond. The area at the center of this dispute is known to the Cowichan as Taktinus, a summer village site on Lulu Island along the south arm of the Fraser River. Cowichan Nation says this was an important seasonal settlement where members fished for salmon. According to their account, Hudson's Bay Company officials first observed the village in 1824, noting it contained more than 108 longhouses, a substantial community by any measure. Today, this area includes things like the Country Meadows Golf Course and other developed lands within the city of Richmond. In August 2025, the BC Supreme Court ruled that the Cowichan Nation holds Aboriginal title over more than 800 acres, roughly 6 square kilometers of their traditional village territory in what is now Richmond. The judge did a few crucial things: recognized Aboriginal title over that defined area, described Aboriginal title as sitting above the BC Land Title Act, effectively treating it as a superior form of title that can invalidate government-held titles created under provincial law, invalidated some city and federal land titles within that area. Though notably, the ruling did not invalidate any private property titles, encouraged the federal and provincial governments to negotiate a resolution with Cowichan rather than leaving everything to litigation. So right away, you can see the tension. The court is saying Aboriginal title is real, ongoing, and superior to government land titles, while at the same time trying not to immediately disrupt private ownership. The Cowichan Nation has gone out of its way to reassure people that this is not an attack on private homeowners in the area. In a public statement, they said their case has not and does not challenge the effectiveness or validity of any title held by individual private landowners. The ruling does not erase private property. However, they also acknowledge there could be practical effects down the line. Their lead lawyer has previously said that if Aboriginal title were declared over someone's private land, that might mean the private owner would need the consent of the nation before selling, and some kind of compensation from federal or provincial governments might be required to address the conflict between titles. Cowichan also emphasizes that they are not trying to deepen divisions in the community, and that some arguments being used by Richmond and the province run against ongoing reconciliation efforts. So their message is, we're asserting our historic and legal rights. We're not here to evict you from your home, and if there are impacts, it's the province that should be on the hook to fix them. The real legal and political explosion comes from one central conflict. Can Aboriginal title and fee simple private property peacefully coexist on the same land? The BC government's own lawyers say, not really. Following the Richmond ruling, BC's Attorney General, Nikki Sharma, went out publicly to sharpen the government's stance before a heated public meeting in Richmond. She said she will not accept the BC Supreme Court's conclusion that Aboriginal title sits above existing private land as a superior title. According to the government's legal argument, fee simple title, what most private homeowners have, an Aboriginal title. Both entail a right to exclusive use and occupation of the land. Because they both claim to be exclusive, the province says they are incompatible in their full form and cannot sit on the same piece of land at the same time. Sharma put it very bluntly. Once you have a fee simple title in BC, it has to mean that those boundaries of that land is your land. She called this type of legal instrument very fundamental to our province, and in fact the country, in other words, the province is now arguing, if you have fee simple, that should be the end of the story for that specific parcel. No overlapping Aboriginal title. This echoes an earlier position the province took in another case we'll discuss later, where its lawyers argued that even if Aboriginal title once existed, the coexistence of that title is inconsistent with and displaced by the estate of any private landowner and Crown-granted mineral claim holder. Not everyone is convinced the province has actually fought hard for that position in the courtroom. Critics have accused the BC NDP government of not vigorously defending private property rights, including failing to argue that private property extinguishes Aboriginal title, a line of argument they say could have protected fee simple owners more clearly. Government officials respond that the Supreme Court of Canada has already rejected a broad extinguishment theory, making that argument a legal dead end. Still, the criticism has been strong enough that provincial officials held briefings to reiterate the arguments they did make during the 11-year-long Cowichan case. And this feeds into a broader political narrative that we'll come back to, that the current government is balancing legal defense with a commitment to reconciliation and may be pulling its punches in court to avoid undermining the UN Declaration on the Rights of Indigenous Peoples and DRIP, and BC's Declaration on the Rights of Indigenous Peoples Act. From a legal risk perspective, one of the strongest warnings came from Tom Isaac, a leading Canadian Aboriginal law lawyer with Castle's Aboriginal Law Group. He points to a very technical but extremely important part of the Richmond decision. The judge stated that Sections 23 and 25 of BC's Land Title Act do not apply to Aboriginal title. Those sections are the ones that create what's called indefeasible title, the legal certainty that once registered, your title can't be challenged except in very rare circumstances. Banks, investors, and property markets rely on that certainty. Isaac's interpretation is stark. He says a precedent that will flow from this case is that Sections 23 and 25 of the Land Title Act do not apply to Aboriginal title. Those are not my words, those are the judge's words. And he concludes that private ownership is in jeopardy in BC because of this. In his words, BC is now the only Western economy on the planet where you can't take indefeasible title to the bank. In fact, your indefeasible title is now defeasible. This obviously needs to be corrected. He also accuses Premier David Eby government of trying to speak out of both sides of its mouth, reassuring private owners that their titles are safe, while the legal reality of the judgment points in a more troubling direction. Premier David Eby has acknowledged that this is a hugely stressful time for families and businesses in the Richmond claim area. He emphasizes that the court had assured the government early on that it would issue a decision that didn't affect landowners in the claim area. So those owners didn't have to be told about the case, something that turned out not to be the case. The province is committed to appealing the ruling and seeking a stay of its legal effects during what could be a years-long appeal process. Eby's also asking affected homeowners to share evidence of financing challenges or market impacts on their properties to help support the province's appeal. So we have a deeply uncertain situation. The Cowichan Nation has a significant Aboriginal title victory. The province says private titles will be protected, but is appealing the very judgment that created this structure. Experts say the judgment undermines the security of the land title system itself. And all of this is happening while other massive title claims are winding their way through the courts. The Richmond ruling has made people ask a bigger question. How many other Aboriginal title claims are already underway that could affect existing communities and private properties? One politician is sounding the alarm, Eleanor Sturko, an independent MLA for Surrey Cloverdale. Sturko is calling on Premier Eby and the BC government to publicly disclose all lawsuits filed by First Nations asserting Aboriginal title over land in the province, especially where claims might overlap with existing private property. She argues that British Columbians deserve to know when court cases could affect their property rights. The Richmond decision is just the tip of the iceberg when it comes to Aboriginal title claims in BC. She's particularly concerned that this decision sets a precedent for Aboriginal title trumping fee, simple, the dominant form of private property in Canada. Sturko also points to a previous case in Haida Gwaii, where Aboriginal title was recognized across the islands, including over some privately held lands, as a sign that courts are increasingly willing to affirm large-scale Indigenous title interests, even in settled areas. She accuses the government of failing its basic duty to notify British Columbians about litigation that directly affects their rights, working almost exclusively in secret on land-back arrangements with First Nations behind closed doors without public transparency. The Cowichan case in Richmond itself illustrates how long and opaque these processes can be. The claim began about a decade ago. The trial started in September 2019 and spanned 513 court hearings and trial days, making it the longest trial in Canadian history. Yet none of the private property owners in the Richmond claim area were formally told about the case until weeks after the judge issued the decision in 2025. Why? According to the governments involved, a judge early in the process decided not to inform private property owners, out of concern that their participation would overwhelm the case and make the litigation unmanageable. For homeowners, that's cold comfort. They had no idea their titles might be indirectly affected until after the fact. As one example of the iceberg beneath the surface, Sturko points to a major title case filed by the Shuswap people. In September 2025, a Cowichan First Nation filed a notice of civil claim seeking a declaration of Aboriginal title to all or part of their traditional territories in the BC interior. The claim area includes the entirety of the city of Kamloops, a number of other municipalities, the Sunday Peaks resort ski area, roads, railways, and various privately owned tenures, including fee simple land, mineral tenures, and other Crown-granted interests. To get a sense of scale, the municipal area of Kamloops alone covers nearly 300 square kilometers, more than 2.5 times the size of the city of Vancouver, and is home to over 100,000 people. The Shuswap state in their filing that they are pursuing Aboriginal title in part to prevent the Ajax copper and gold mine near Kamloops, which they say would violate their Indigenous rights, desecrate sacred lands, and cause environmental harm. They also assert that their traditional territory is even larger than the current claim, roughly 180,000 square kilometers, nearly 20% of the entire land area of BC. They outline this area in geographic terms, from Ashcroft and Kesnel in the west and north, to Windermere, the Arrow Lakes, Salmon River, Enderby, and back to Ashcroft. And importantly, they reserve the right to assert Aboriginal title over this entire traditional territory in the future. This is the same nation that drew international attention in 2021 when ground-penetrating radar at the Kamloops residential school site indicated over 200 potential unmarked graves, adding profound emotional and historical weight to their land claims. Back in January 2016, when the BC Liberals were in power, provincial lawyers filed a detailed response to the Shuswap claim. They formally denied nearly all allegations, asking the court to dismiss the claim as an abuse of process, arguing that it appeared to be filed in response to the Ajax mine project, which they said was largely on privately held, lawfully granted fee simple lands. The province emphasized that it holds the underlying title to the lands and minerals at issue, and it has constitutional authority to manage them. While acknowledging that Aboriginal rights and title exist in British Columbia, the province argued that the plaintiff's allegations did not clearly meet the legal tests or specify locations where Aboriginal rights are exercised in a way the province could respond to. The province also questioned the historical basis for such a vast title claim, arguing that Shuswap ancestors lived in bands that were loosely knit networks of extended families. They were not politically unified or organized as a single sovereign over the entire area, and they opportunistically hunted, fished, and gathered for sustenance, and did not have exclusive occupation of the entire claimed territory. Similar arguments were made by the Musqueam and Tia-Sawasan First Nations, who were defendants, not plaintiffs, in the Cowichan Richmond case disputing the existence and legitimacy of Cowichan's claimed historic village at Tucktinus on the Fraser River. And then here is the crucial doctrinal move. The province's lawyers stated that even if Cowichan Aboriginal title once existed, its coexistence is inconsistent with and displaced by the estate of any private landowner and Crown-granted mineral claim holder. In other words, once private or Crown-granted tenures are in place, Aboriginal title cannot still sit on top of that same land. The province insisted that these grants were lawfully granted and remain valid to their full force and effect. Finally, they argued that any infringement of Indigenous rights was justified by pressing and substantial objectives for the collective good of BC society, including development of agriculture, forestry, mining, the general economy, wildlife regulation, environmental protection, and the creation of public services like justice, transportation, healthcare, education, and social welfare. They claim that Indigenous peoples, including the plaintiffs, have also benefited from these developments, and that the cumulative effect of provincial actions since 1871 has been to justify any infringement of established Aboriginal rights and title. Those are very strong words, and they mark a sharp contrast with the current NDP government's approach in court. The arguments I just described were made in 2016, when the BC Liberals were in power. Since then, under the BC NDP, critics like Sturco say the province and Canada have been giving a half-hearted defense in cases like the Cowichan trial, not making the most aggressive arguments, and avoiding explicit talk of extinguishment of Aboriginal title. This, they claim, is part of a broader strategy to avoid undermining reconciliation based on UNDRIP and BC's Declaration on the Rights of Indigenous Peoples Act, which the NDP passed in 2019. Meanwhile, Sturco alleges the government is working on land-back agreements behind closed doors, keeping British Columbians in the dark about negotiations that could affect public and private land. So as we look at Richmond, Kamloops, Sunday Peaks, and beyond, we're really seeing a legal system still trying to fit Aboriginal title into a land framework built on Crown grants and fee simple, and political parties debating how hard to push back against Indigenous claims while still committing to reconciliation. Let's step back and talk briefly about what Aboriginal title actually is in legal terms and why it sits at the heart of fights, like the Cowichan case in Richmond or the Shuswap claim around Kamloops. Legally, Aboriginal title is the doctrine that Indigenous peoples' land rights did not disappear when colonial powers claimed sovereignty. Those pre-existing rights persist unless and until they are lawfully extinguished. In Canada, that's been refined into a clear definition. It's an inherent Aboriginal right to land or territory, meaning it comes from Indigenous people's own occupation, laws, political systems, and relationship to their territories, not from a government grant. It's described as sui generis, a unique kind of right that doesn't fit neatly into standard property law categories. It's a collective right held by the Indigenous group as a whole, not by individuals. So when a court declares Aboriginal title over land, it isn't giving Indigenous people something new. It's recognizing a right that existed before the Crown and continues to exist alongside the Crown's asserted sovereignty. This is part of a broader body of law in many common law countries, sometimes called native title, original Indian title, or customary title, and it's been developed through court decisions, constitutions, treaties, and legislation in places like Canada, Australia, New Zealand, and the US. It's important to distinguish Aboriginal title from Aboriginal rights more generally. Under Canadian law, Aboriginal rights protect specific practices, customs, and traditions that are integral to the distinctive culture of an Indigenous group, hunting, fishing, ceremonies, or resource use, for example. To qualify, a practice must be of central significance to that society, something that made the culture what it is. These rights can be recognized even if a group can't prove title to a particular parcel of land. By contrast, Aboriginal title is a subset of Aboriginal rights that deals specifically with the right to the land itself, not just to do particular activities on it. So you can think of it this way: Aboriginal rights, what you can do, practices tied to culture. Aboriginal title, where you can do it because you have a property like interest in the land itself. That's why title cases like Cowichan in Richmond or Shuswap around Kamloops and Sunday Peaks feel so high stakes. They're not just about a right to fish or hunt in a place, but about who ultimately holds the underlying land interest. The Supreme Court of Canada has described Aboriginal title as similar in many ways to fee simple, the standard private property form in Canadian law, but with important differences. Where the two overlap, Aboriginal title includes the right to decide how the land will be used, the right to possess, occupy, and enjoy the land, the right to the economic benefits of the land, and the right to proactively manage and use it. That's very close to what a fee simple owner has: exclusive possession, the ability to use and benefit from the land, and the ability to decide whether to log it, farm it, lease it, or develop it. But Aboriginal title is different in three crucial ways. 1. T's collective, not individual. The title belongs to the entire Indigenous group, not a single person. 2. It's inalienable, except to the Crown. Aboriginal title land cannot be sold or transferred on the open market like ordinary private property. It can only be ceded or surrendered to the Crown, the government. 3. It's bound by intergenerational obligations. The land cannot be used in a way that prevents future generations of that nation from using and benefiting from it. So, for example, a nation couldn't validly approve a land use that would permanently destroy the land's ability to support the community, because that would violate the collective intergenerational nature of the title. In short, Aboriginal title is a powerful property, right? Anchored in Indigenous law and history. But it's collective, constrained in how it can be alienated and oriented toward long-term stewardship rather than individual sale and speculation. Courts don't just assume Aboriginal title exists everywhere. Indigenous nations have to prove it according to a legal test. In Canada, the modern test comes mainly from Delgamuukw 1997 and was reaffirmed in Cowichan Nation 2014. To establish Aboriginal title, an Indigenous group must show three things. 1. The land was occupied prior to British sovereignty. 2. If they rely on present occupation as evidence, there must be continuity between present and pre-sovereignty occupation. 3. At the time of sovereignty, that occupation was exclusive, or the group had the intent and capacity to control the land. Let's unpack that in plain language. 1. Occupation before sovereignty. The relevant time is when the Crown first asserted sovereignty over the area, and that date isn't the same everywhere in Canada. Courts have said you can't just use the Royal Proclamation of 1763 as the universal date. Sovereignty was asserted at different times in different regions. For British Columbia, the Supreme Court has accepted 1846, the date of the Oregon Boundary Treaty, as the key sovereignty date. To prove occupation in law, Indigenous nations can show many kinds of evidence: permanent or seasonal dwellings, cultivated fields or enclosure, regular and intensive use of an area for hunting, fishing, or resource gathering. In Cowichan Nation, the court specifically recognized that even semi-nomadic peoples moving seasonally over a large area due to the land's low carrying capacity can still establish title over a broad territory, not just isolated village sites, if there is a pattern of regular use and control. 2. Continuity. Continuity doesn't mean every square meter has been continuously occupied without interruption. Instead, courts look for whether present occupation is rooted in pre-sovereignty times, whether the group can show a believable line between their current presence and their ancestral use of the land. 3. Exclusivity. Normally, exclusivity is shown by evidence that the group was the sole occupant of the land at sovereignty, but perfect isolation isn't required. If other groups were present, exclusivity can be shown by traditional laws or customs governing land use, evidence that others needed permission to cross or use the land, agreements or treaties between Indigenous groups about access. The Supreme Court has also recognized that in some areas, overlapping or shared title may exist, where two or more nations jointly held and controlled territory, giving rise to joint title based on shared exclusivity. All of this has to be assessed from both a common law and an Indigenous perspective. Courts look at Indigenous laws, customs, practices, and governance as evidence of how land was held and controlled. They've emphasized not forcing Indigenous land relationships into square boxes of European property concepts, but instead trying to faithfully translate pre-sovereignty Indigenous interests into modern legal rights. If Aboriginal title exists, what can governments do on that land? Canadian law sets some strict conditions. 1. Duty to negotiate in good faith. The Crown has a legal duty to negotiate in good faith to resolve land claims, and courts have said negotiation is preferred over endless litigation. This is meant to encourage agreements, treaties, and modern land fake claim settlements, instead of having every dispute decided only in court. 2. Consent versus justified infringement. On lands where Aboriginal title has been established, federal and provincial governments cannot simply approve projects that adversely impact the land without the nation's consent unless they can meet a high justification test drawn from the Sparrow case. That justification test requires a compelling and substantial objective in the broader public interest, and the government must respect its fiduciary duty, its special obligation towards Indigenous peoples. 3. Extinguishment is highly constrained. Historically, some jurisdictions allowed governments to extinguish Aboriginal title relatively easily, even implicitly. Modern Canadian law has moved away from that. The Crown cannot extinguish Aboriginal title without the free, prior, and informed consent of the proper title holders. Even when title is infringed or affected, questions of compensation arise, often tied to constitutional property protections or breaches of fiduciary duty. Alongside litigation, the federal government created a comprehensive claims process to deal with areas where historic treaties never addressed title, which includes most of British Columbia. This process was largely designed to achieve certainty by extinguishing or modifying Aboriginal title in exchange for treaty-style settlements, land, money, and defined rights. Many First Nations have criticized this model as a way to cede, release, and surrender their title under another name and have been wary of entering into these agreements. At the provincial level, BC eventually created the BC Treaty process in the 1990s after protests and roadblocks driven in part by resource industry uncertainty over unresolved title, made it clear the status quo was unsustainable. But again, many nations have dropped out or refused to participate, arguing the process is geared more toward clearing the way for government and corporate interests than truly honoring their own understandings of original title. All of this theory lands hardest in BC for one simple reason. In most of the province, there are no historic treaties, meaning Aboriginal title was never formally dealt with or extinguished in the Crown's own legal framework, except for the Douglas Treaties on parts of Vancouver Island, Treaty 8 in the northeast, and a handful of modern treaties like the Niska and Tisa-Wasson agreements. The legal position from many Indigenous perspectives and increasingly from the courts is that Aboriginal title continues to exist over huge areas of the province. That's why the Calder case in 1973, which acknowledged the existence of Aboriginal title in Canadian law, was such a turning point. It forced government to accept that unextinguished title could still be out there. The Delgamuc and Seacott Tin decisions, which clarified the test and extended title beyond small sites to entire traditional territories, were game changers. And it's why cases like the Cowichan claim in Richmond or the Shuswap claims around Kamloops and Sunday Peaks are so consequential. They are the concrete, on-the-ground application of this doctrine in places where hundreds of thousands of non-Indigenous people now live, work, and own property. Aboriginal title is not an abstract legal curiosity. It's a living doctrine that, recognizes Indigenous peoples' inherent connection and jurisdiction over their lands, sits uncomfortably alongside a system built on Crown grants and private fee simple, and forces governments, courts, and communities to confront a basic question. How do you reconcile a property system built on the assumption of Crown sovereignty with centuries-old Indigenous systems that never consented to give that land up? That's the tension at the heart of the Richmond ruling, the Kamloops and Sunday Peaks claims, and many others across BC. And it's why debates over Aboriginal title are so emotionally charged, politically explosive, and legally complex.